My name is Emina Pori-Cannon. I am the founding attorney of Pori-Cannon Law, where we have the distinct pleasure of working with approximately 200 home care providers across New York State. Wage parity is a subject that has been near and dear our hearts ever since it came on the scene in 2011, 2012. And then the changes that we're discussing today were enacted as part of the budget process in 2020, right in the midst of COVID. So home care typically has a lot of turnover, so I will not assume that all of you listening in today have been around since the enactment of wage parity or since the enactment of these certifications that we're going to be discussing today. So I do want to do a little bit of an overview and a background for all of you before we get into what has exactly changed. Before I do, just a few housekeeping items. Many of you on the line are clients, and we love speaking with you, but today's presentation should not be construed as attorney-client privileged communication or advice privileged under the attorney-client privilege. This is strictly for informational purposes. Before you decide how to comply with any of these requirements, please be sure to speak with your retained counsel in case we are not such counsel. I also know that we have on the call a number of individuals who are in the accounting space, whether in a consulting capacity or an actual CPA title. And I am not going to answer specific questions for specific situations. I encourage you to reach out to us after today's webinar. This is going to be, again, provided largely for informational purposes so that everybody is aware of the deadlines that these changes were made and what they need to do to start preparing for implementing and complying with this. But the devil is always in the details, especially with something with the ramifications and implications of the wage parity certification. So we will review predominantly the changes that came, was it last week or the week before? But the last few days, the Department of Health circulated updates to these forms and provided a guideline document on what has changed, and we will review all of that. And basically set the timeline and expectations for all providers in the home care continuum, whether they are payors, whether they are LICSAs or former FIs. Everybody is covered by the guidance that came out a few days ago. So as far as the wage parity law is concerned, if you have ever worked in construction or have heard of prevailing wages, wage parity law is very similar to that. It sets the minimum hourly compensation for employees working on Medicaid cases. And then in addition to wages, it sets the minimum for the add-on, what is referred to here as the supplemental benefit. And so that can be additional wages, or it can be an actual benefit like health insurance, a 401k contribution, a pension fund, an education fund, all sorts of benefits. They can be tax-free benefits or taxable after tax benefits. There are many different ways to structure them, and many different ways have been developed over the years since the wage parity law came into effect for providers to comply with this. Many of you know on the line that I have a payroll and human resources company as well called ForWork. And at ForWork, we help providers break down these benefits and wages per contract, per type of work, so that these types of reporting obligations can be met. But the minimum compensation is reset every year, as you know, by the legislature. We're hoping it will not be raised again because your rates, your reimbursement rates are certainly not keeping up with what New York State and Albany expects of you as far as minimum wages. But the minimum compensation that must be paid for wage parity covered hours is the New York State home care worker minimum wage, okay? It is not the statewide minimum wage. And just to be clear, I saw a question pop up, but I'm not going to answer anything because it's going to take me off track. This is applicable to providers who have work cases, patients, billable hours in New York City, Westchester, Suffolk, and Nassau counties. So the entire Long Island, which Nassau is omitted here, but the entire Long Island, Westchester, and New York City. If you are on the call and you have partial operations further upstate than Westchester, or you have no operations down in the city at all, this is not applicable to you. There are constantly rumors that wage parity will be expanded statewide, and I really don't know how the state would support, frankly, that such a cost, because wage parity is built into the Medicaid budget. And so we are in the midst of the budget season, and every year home care providers fear of what they will receive from New York State. It's always some twist of fate. And so hopefully, I don't see how the wage parity rates could be increased given the budget constraints, or how the wage parity coverage area geographically could be expanded. Now, when the law came into effect in 2020, it required certain accountability, for lack of a better word. It required certain accountability from providers who were covered by wage parity to certify to how they were actually meeting their wage and benefit obligations under state law. And again, those are variable. From year to year, they vary. PTO is a way that employers can satisfy wage parity as well. All compensation is also creditable. So the state in 2020 woke up and said there are a lot of schemes around how wage parity is satisfied. You know, there was a lot of prosecution about captive arrangements and other things that the state thought were questionable, illegal, and a number of them resulted in high-profile attorney general settlements. It was a tough time for the industry, but I think prompted by those investigations and what were allegations of fraud, the state put out certification forms, two forms, the LS300 and the LS301. The LS300 is to be filled out by the provider, and the LS301 is to be filled out by a proper auditing or accounting arm of the provider to certify compliance of the information that is on the LS300. So under the LS301 process, the auditor is certifying the information that was reported on the LS300. And in that certification process, the auditor has the right to ask for backup information. When the forms originally came out in 2020, there was an error there that required the auditor filling out the 301 form to certify that they had conducted an audit of everything reported on the LS300 in accordance with GAAP principles. Now, this was a problem because, and I'm not an accountant, but having spoken with the Society of the CPAs and worked with them years ago when this whole issue erupted, the problem was that under those auditing procedures, samples are evaluated. And here, the way that the certifications were requested and written, it suggested that the auditor actually had to look at everything being reported on an employee basis. And so the State Association for the Accountants said, there's no way we can do this in accordance with GAAP. This is inherently inconsistent with GAAP, which are the standards for the accountants. And so they rose a challenge and advocacy and really tried to educate the state about how the forms need to be revised to conform with the proper auditing standards. We just got those revised forms a few days ago, folks. So this has been a multi-year battle between the industry insiders, the accountants, their trusted advisors on that side of the house, and how to complete these forms. Now, you will see that there are requirements for certification to the payors, to the state, by CHHAs, to CHHAs, FIs, The whole continuum is there. And there were, it was confusing for everybody as to how to fill these out previously. Not to say that the new forms don't have some of their own questions and ambiguities, but at least now they were drafted in accordance with these auditor standards. One thing I want to mention is that these forms are extremely important because they serve as the basis and could serve as the basis for a False Claims Act, which has a very extensive statute of limitations. New York State DOL, OMIC, Attorney General will also rely on these forms if they are auditing or investigating a provider for compliance with the wage parity law. So these are short forms, relatively short forms, but a lot of information needs to be provided and a lot of weight will be given to the information there. And the individuals certifying to that information need to be absolutely sure as to what they're signing off on, because absolutely personal liability could attach, criminal action, investigations, obviously recoupment of hours that are billed that are misreported on these things, wages that are alleged to have been paid but weren't, benefits also that were alleged to have been provided but weren't. So, relatively straightforward forms, but a lot of potential downfall if not done correctly. So, that's a little bit of the background information I wanted you to kind of know where we started with these documents and what's happening with this. So, at a high level, the purpose of the LS 300 form is the employer certification, right? This is the provider certification, and then the LS 301 is the form that discloses the auditor's information. Now, with respect to the changes, and we went over this a little bit, 2020, the major change is in the process that is used to audit and certify the correctness of these forms. The guidance applies to LICSAs, CHHAs, MCOs, and FIs. I know we are now a single statewide FI state, but for purposes of the reporting, and you will see the past years that are in issue now, entities that operated as FIs a few years ago are required to comply with these tools, with these disclosures. Okay, so first of all, deadlines coming up. The LS300 must be submitted to all MCOs and CHHAs by May 31st, and the LS301 has to be submitted through the eMedNI portal by May 31st as well. The portal is expected to be updated to accept the 2025 certification. Access to eMedNI. I'm not allowed to, so I wouldn't know if they have updated it. But if you're logging in on any regularity, just double check. So a few clarifications here on the timeline. So 2025 is the one that is the most important. For CHHAs, the reporting obligations are a little bit different. The LS300 must be submitted to the plans by April 30th. And the LS301 is also going through eMedNI from CHHAs by May 31st. And for MCOs, the LS301 must be submitted to the DOH through eMedNI by May 31. The MCOs have a lot of obligations with respect to these forms. A number of you had reached out over the years because the law didn't change, right? The law did say that these certifications have to be provided. Pending the accounting industry's advocacy regarding the LS301, there was a position by the state that the form is not going to be in use and that it is under revision. And so MCOs were caught in a bit of a tough spot because they are by law required to collect these certifications, but under the state's guidelines, they were not required to actually use the certifications that were on the books at the time, the unrevised ones. So, the MCOs now have to go through the process of reviewing all of these from prior years, and the questions come up as to how much audit and work and review they have to do for all of the providers who will be submitting the forms to them. Okay. In addition to clarifying the deadlines for the upcoming reporting cycle, the guidance establishes a standardized reporting schedule beginning um, with the 2026 calendar year, so this year, but it will be reported in 2027. So for CHHAs and the statewide FI, the reporting framework is outlined here. It's going to go to June. So we have a spring process and deadlines now, starting with the reported year of 2026 that will be submitted in 27. We're going to go to that June 1 cycle with the LS301 form and any supporting documentation being submitted on October 1. And then, as you have before, providers, you will have to continue certifying annually to your wage parity compliance through eMedNI, and this is due December 1, as well as for the MCOs. Okay. So I've been speaking with a lot of clients about all of this, and there's still a large segment of the auditing and accounting industry that is not familiar with wage parity. And so the first thing I have advised clients who have reached out thus far is to make sure that they're speaking and making their accountants aware of this guidance, of this law, of what it requires, and then work with the accountant on what supporting documentation he or she may need to actually prepare the LS301. That was certainly the problem when we tried to complete the forms before. There were a few accountants who tried to complete the forms and do the calculations and extrapolate things per MLTC. And we went through all of those challenges of the reports. But I mean, again, ultimately, no accountant, I believe, submitted this to the DOH or to an MLTC. But there were those complications about the proper reports for this that the accountants were expecting to see so that they could comfortably complete the LS301. So initially, as I still continue to recommend, make sure that your auditors are on top of these new requirements, these new timelines and everything. So the LS300 reports the hours worked and compensation paid to home care aides. The LS301 still verifies the wage parity expenses reported by providers through supporting financial documentations. So in practical terms, as I think has been illustrated by what I've been explaining, the LS301 functions as the mechanism through which the data reported on the LS300 is verified by an impartial third party that has done an audit in accordance with the set standards. Okay. Hopefully the providers will find this interesting. I'm sure the financial auditing and accounting folks on the call will. But under the guidance, providers must submit the DOL Form 301 together with independent financial verification performed by a CPA. Specifically, the LS301 must be accompanied by one of the following: audited financial statements, which a lot of providers don't do unless they are required to, unless they are a nonprofit or a fee-for-service, perhaps. I don't know many LICSAs that have audited financial statements. Or a CPA performed agreed-upon procedures report verifying the wage parity expenditures reported by the provider. Excuse me. For the 2025 reporting cycle, again, this form must be submitted to the DOH through the eMedNI portal. And beginning with the standardized reporting schedule that we mentioned above, providers will be required to submit the LS301 and the auditing accompanying audit or the documentation performed pursuant to agreed upon procedures by October 1 each year for the prior calendar year. The DOH also clarified that providers who previously submitted audited financial statements or earlier versions of Form LS301 for prior reporting years are not required to submit revised filings. Those previously submitted materials will continue to be considered compliant. Again, we are reporting here what has been stated in the DOH guidelines. I'm not really sure, given everything that the Society of the CPAs had articulated, I don't know how the audited financial statement conforms to the LS301 requirements before. And this is what that's referring to. There have been providers that did complete the LS301 under the old standards where the DOH said, hey, we're revising the form. We heard the Society of the CPAs loud and clear. We're going to revise it. Nonetheless, some providers did complete the 301 and they had their accountants certify in the 301 that the 300 data was accurate. The DOH is saying that's good. You don't need to resubmit it. If you are such a provider, make sure you know which years you had submitted to, because as we're going to talk about in just a few slides, there are prior years for which you will need to prepare information. A significant aspect of this updated guidance is the continued recognition of the agreed upon procedures as an alternative to a full financial statement audit. Again, probably something that only those accountants on the call would appreciate. I do not operate in that world, and you know me as a lawyer, a lot of wage and hour and labor law lawyer, but bear with me as I walk through this. The AUP framework was developed by the DOH and the DOL in consultation with the accounting professionals, and this is the Society of CPAs for New York. These procedures must be conducted by a CPA in accordance with the attestation standards of the American Institute of CPAs. So under the approach that's outlined, a CPA performs a series of standardized verification procedures designed to confirm that the provider's wage parity reporting is accurate. These procedures may include a review of the payroll records, reconciliation of hours against any benefit accruals, and verification of expenditures for specific benefits, such as paid time off. There's a lot actually to unpack here in this third paragraph that is not necessarily accounting speak. So there are all sorts of records. All of you have comprehensive payroll systems and reports at your disposal. So it is not a problem of gathering the data. But what this is saying here is that the CPA, as part of their LS301 procedures, may be required to reconcile hours accumulated against any benefit accruals. One of the problems that we had run into before had to do with hours that are accumulated across work performed across two MLTC contracts. So one work week, 30 hours total, 16 worked at one MLTC patient, and 14 hours worked for a patient under a different MLTC. And yet the employee accumulated 1 hour for each of the 30 hours worked, right? The common formula to accumulate sick time in New York State, 1 hour for every 30 hours worked. So that had been a question in my mind for a long time on this reconciliation, this reporting function. And then verification of expenditures for specific benefits such as paid time off. Now look, that's a pretty easy one. Either the paid time off was accumulated and paid out or it wasn't. But what I'm wondering is whether the auditors will be expected to audit a bit unconventional programs and plans that many providers use to satisfy their wage parity obligations. So, to be seen how far the accountants and the auditors will be expected to go before they are satisfied that they can fulfill the 301 obligations. The verification question could be an ambiguous one. The verification requirement, excuse me. How much does the auditor have to actually do before they are comfortable and can certify? And then the MCO that is receiving the information, what is their duty legally? How far do they go to check the veracity of the reports being provided to them? Because if they're certifying to the DOH that they've conducted their obligations, and it turns out that one of those verifications or LS301 forms is inaccurate, the MLTC is, quote, on the hook as well as the provider who provided intentionally or unintentionally incomplete or inaccurate information. So the stakes are very high for the payors as well in this whole continuum of wage parity, certification, and accountability. Excuse me. Okay. Importantly, for reporting years 2021 through 2025, providers may complete these reviews at the agency level rather than separately for each managed care contract, therefore allowing a single review to cover wage parity expenditures across the agency's contract. So, in the example I had given above, where the PTO is being accumulated for 30 hours of work in a single week, that hour of a benefit and whatever is paid out for it does not have to be divided up across the contracts. Okay, we will see that starting with the reports for year 2026, that is not the case. Okay. The DOH guidance also signals a significant compliance change that providers should begin preparing for now. We are entering into April, but you will be required to report for a full calendar year 2026. So LICSAs and the statewide FI will be required to perform wage parity verification at the contract level. So what I was talking about just on the prior slide. In practical terms, providers will need to prepare separate audited financial statements for each MCO or CHA contract. Currently, for the years at issue here, they may conduct a single agency-wide audit or AUP review covering all wage parity expenditures. The shift to contract-specific verification will likely increase the administrative and accounting costs for agencies. I know that's not the news that you want, but this is the expectation for this year. If you are in the process of lobbying for anything, this might be something that you throw in there, that this implementation for 2026 is going to be administratively burdensome and expensive. Dividing up your data per contract is going to be absolutely burdensome because it's typically not tracked that way, right? Unless you are pulling that information from your EVV system per contract and then allocating it that way in your payroll system where benefits, wages, etc., reside and are analyzed and reported for these purposes, it is not going to be a natural distinction between how they're accrued and where they are allocated. So, as a practical matter for this year, as you're entering April, think about this reporting obligation and immediately set up your payroll systems so that the work, which is already being divided by payor in your EVV systems, that the work is actually coming in and the hours and the benefits accumulated across those different plans are separately earmarked for these reporting purposes. Okay, that was quick. A summary, and I apologize, I am extremely faint. I'm not feeling well. I do have a few questions. Let me see if any of these are appropriate to answer as a group. So bear with me. As I'm doing that, feel free to put your questions in the chat. I do see a few raised hands, but you are not able to pose a question that way. So I strongly suggest that whatever questions you have, you put them in the chat. And because I'm not at my best today, I would suggest that if we have a number of questions that we're not able to get through today, again, it is not appropriate to provide specific legal advice on a topic that is quickly evolving like this. Please feel free to email me and suggest that we discuss some of these in a separate webinar. Is that we let's see, that we can hold a separate webinar, folks. Okay, the question is, can we receive a copy of this recording? Sure, if you want to email me, I will send you a recording. Today was not my best performance. I'm so sorry. I'm trying to be well, but I'm happy to share it. The LS301 is due on 10/1/26. The annual certification through eMedNI website is due 5/31. How can benefits possibly be broken up per MLTC? Benefits are provided to the aides based on total wage parity benefits due, not based on which contracts they worked for. So remember, you are providing benefits on a per hour basis, up to the first 40 hours that they work each week. So if they worked uh, 40 hours and they are receiving $2 on a card, 50 cents of which is for transit, you will need to break up if they work 20 hours on one contract and 20 hours on another. You will need to report that the 50 cents out of the $2 that is going on the card, 50 cents that is allocated to the transit, was earned under contract ABC during the first 20 hours in the week and not during the second 20 hours in the week. It's not impossible, right? I think the complexity largely is with PTO because PTO is accumulated against a total. But if you are doing a per hour accrual, which most benefits are, you should be able to break it up. It's just a matter of tracking your reporting and setting it up to pull apart the data coming in from your EVV system that way. Yes, prior years forms will be due under this whole process. Let's see. 2021 is the first one that will be due. 2025 is due this year. And what else? There's a question about revising the LS300 for prior years. This is a conversation you should have with your attorney under privilege. And there's someone saying that they have updated the certification. They just checked in the eMedNI. So I appreciate you checking on that and putting it here in the chat. I don't know if you should revise things. Anytime you revise, submit, amend, withdraw, anything that you put to the government, you risk the possibility of them taking a closer look. So in regards to that question about whether you should revise, I do suggest that you speak with your lawyer. I would want to know, for example, if I were the lawyer being asked the question, what is the reason for the revision? We do have guidance from the DOH that said if you had submitted the LS301 previously, you don't need to resubmit again. There may be some defense in that you did the best you could with the certification that you prepared at this time. I have some general questions slash comments about what was the thinking behind this new requirement. You may have come in a little bit late to the presentation, but the law, when it was passed, always required some sort of certification, reporting, and disclosure of the expenditures for providers And so we are now just getting to the point where the certification by the auditor is being flushed out. There were errors in it when it was originally published. Okay, I still see raised hands, but I don't see questions there, and I don't know that we're able to answer questions from raised hands. So I will I will say goodbye to all of you. Thank you so much for tuning in. If you believe that this conversation warrants a further discussion, by all means, send me an email. Um, I will happily share my slides. The contact information is there, but we can certainly do a deeper dive as the deadline approaches. If you want to send specific questions, but you do not want to be attributed to the question, we can certainly have just an FAQ type of webinar as well. I know a lot of providers are struggling with the open questions raised by these new guidelines and the forms. Like I said, I've been talking to a lot of providers and their accountants as they're trying to get a hold on what's really being expected and what's reasonable to be accomplished so soon. So please don't hesitate to reach out if we at Pori Canon Law can be of any assistance. Thank you so much for the attendance. I appreciate your time and attention. And for those celebrating, happy holidays and thank you again. Take care.